today by Dr. Lauren Robinson. Dr. Robinson is a clinical and forensic psychiatrist. She is currently the adjunct assistant professor of forensic psychiatry at Northwestern Feinberg School of Medicine, where she teaches medical ethics and forensic psychiatry principles to medical students, residents, and fellows. She has also served as an expert witness for a wide variety of civil and criminal issues at the interface of psychiatry and the law, including psychic damages, malpractice, undue influence, and testamentary capacity. Dr. Robinson, we're so excited to have you with us today. Thank you so much for taking the time to do this. And I would like to go ahead and kick us off with sort of a basic question, but what gets to the root of you and your passion and sort of your path into forensic psychiatry. Can you start to tell us a little bit about your background, your focus within the medical field, specifically within psychiatry, and and let us know what inspired you to pursue this career path? What may have been the Kickstarter? I know we were talking about previous to this, you may have had a bit of a non-traditional path, so I'd love to hear from you how sort of your career and everything just came to be.
Yeah, absolutely. It's such a pleasure to be here with you both. So I did a little bit of a non-traditional path. And initially after college, I did research for several years at the CDC, and then I decided, I think I want to do medicine. I like working with people. I did not know I wanted to be a psychiatrist, but it's just one of those things. When you do medical school, you rotate through a lot of different clinical clerkships to try to figure out what you like, what fits you, what drives your passion. And I was on my psychiatry rotation, and I was on an inpatient ward, so treating people who were hospitalized against their will, psychotic, manic, after suicide attempts. So these are very, very sick, acute patients. And I was blown away by the compassion of the residents and my attendings. And I just thought it was so different and so much more interesting to me in terms of actually sitting down and talking to a patient and getting to know them and what was going on with them, as opposed to I was a little frustrated in medical school with the knowing the sodium. You have to know sodium, right? But knowing the sodium values and this, but I just love talking to people. And so then I decided to pursue a residency in psychiatry. So I came up here to Chicago, went to University of Chicago, and I was very fortunate when I was there to be able to do a fellowship in medical ethics at the McLean Center. So they have a center for studying medical ethics, and it's clinical, meaning we actually rotate through the hospital and we're in the consult service for the hospital for ethical issues that come up. And I just love the interface. Really, it's several different disciplines. It can be psychiatry, but it's all of medicine. It's ethics, it's philosophy, it's law. So I've always loved this intersectionality of disciplines. What's happening at the overlap between these silos. They don't have to be siloed. And then I growing more interested in the law, I was always fascinated with how mental illness is really viewed by the law, and how do we explain and understand and contextualize mental illness when we're making these very serious decisions about what happens with people who are accused of a crime. And so then I decided that I was going to pursue a forensic psychiatry fellowship. And so that's an additional year. And it's a year that is very, very different from clinical medicine. You are not, for the most part, treating patients. So these are objective evaluations that you're doing. And so there's not this ethical principle of doing no harm necessarily. So you're not forming a treating role. You're doing these evaluations for the court to help them understand what's going on and to make what's the decision that's right and that is ultimately just. And so after that, I continued in private practice. And so I have a clinical practice, and now I'm in private practice for forensics as well, in addition to the teaching that I do academically. And so I consult with different lawyers, consult with me about questions that they have, and I can, comment or see if I think a case has merit that I can work on with them.
Yeah, I'd love to actually ask you. One of the questions that we had for you today was whether you had seen both like the inpatient and outpatient setting. I'm fascinated personally just by the environment of an inpatient psychiatric ward and what working in a setting like that would look like. How would you say, I guess, it's probably not comparable to the work you did in like forensic psychiatry or, even at the CDC. How would you explain that to someone? Like what were you seeing on a day-to-day basis in the inpatient ward setting?
Yes, and so I worked on the inpatient ward for a couple years at Northwestern right after fellowship. So I was an attending there, and I did that full time. And so I saw many, many patients, thousands of encounters. And so a psychiatric unit is essentially, sometimes they're freestanding, but often they're part of a greater hospital system. And
Mhm.
it's a part of the hospital that is a unit that is locked. And the patients that go up there, it's very different way of being admitted to the hospital. So usually they're admitted to the emergency room. So something happens, either a loved one bring somebody in, they come in, the police and ambulance brings them in, and the types of things that we most commonly seen are suicidal thoughts or a suicide attempt, psychosis, so people who have a psychotic disorder and who are hallucinating, hearing voices, very, very paranoid, very fearful that something will happen to them. Or
Mhm.
it can be mania, so a manic episode of bipolar disorder, and all of these things can impair judgment sometimes. And so what happens
Mhm.
is a resident evaluates them in psychiatry, and what they do is that they essentially certify them, which is it's a legal term that we use, that we as psychiatrists are essentially admitting them to a locked unit. And so it's actually taking a lot of somebody's rights away. I think the only
Yeah.
thing that's comparable is being arrested. This is
Wow.
done, yes, and then this is done with some checks, because another doctor has to evaluate once they're admitted.
Mhm.
But it is a serious thing, and it's something that psychiatrists do. It can only be done if we feel that they're a danger to themselves or a danger to other people, or gravely disabled as a result of a mental health condition or an intellectual disability. So when they're on the psychiatric unit, usually it's with many other patients as well. That's the way it was at Northwestern, but sometimes it can be divided by, mood or psychosis or addiction. It's more often than not, I think, all together, or all these patients are together. And it's an environment where a lot of people are quite sick. It's the most acute, highest level of care that we have in psychiatry. And so the experience is every single day is something different. It's very fast paced. It can be very rewarding to see people get better so quickly, because they're coming in so sick. But with treatment, you can get them better, and you can get them out of the hospital. Sometimes there is a lot of forensic application here, because sometimes when people refuse medications on the psychiatric ward, we actually have to take them to court to give them medications over their objection. It's not like it is on the hospital side necessarily, where if we see somebody lacks the capacity to make a decision about something, it could be a surgery, it could be medication. The doctor just has to say, a physician just has to say, they lack capacity. They don't understand the risks and the benefits. They can't manipulate the information in a conversation. But it's totally different in psychiatry. In psychiatry, we have to petition to the court that we think this person needs medication over their objection. And it's a long wait. It's several weeks that we wait. And while we wait, they're actively ill on the inpatient ward. and that's not good for them. I mean, they're psychotic, they're manic, and so we have to wait. And then I go before a judge, and I am examined and then cross-examined to ensure, and it's a form of checks and balances, so that we're sure that psychiatrists aren't abusing their power and just treating people who don't need to be treated. But it's very cumbersome and it takes a lot of time, and it can be very frustrating on the point of a psychiatrist when somebody clearly needs help and we have to go
Mhm.
through so many hurdles and so much time in order to give them the care that they really need.
Yeah, it's interesting that you say that, and kind of goes back to your point on the interplay of ethics, the law, and medicine, and the point, like the analogy you made of the psychiatric ward to the prison. I took like the last psychology classes that I took were back in high school and college. Part of that curriculum was sort of diving into like the complicated history of inpatient psychiatric wards and the like. One of great professors that I had, she would, sort of discuss with us like what the state of psychiatric wards were like, I don't know, when they first started, let's say, and there weren't any of these sort of like checks and balances. Psychiatric wards was like imprisoning someone, holding them against their will, medicating them against their will. They were all over medicated, and like quality of life was very low. And so it's nice that they put these checks and balances in place. It seems like there's been a lot of progress. However, for you, I think as like the physician, treating them must be so frustrating, and you feel like you're unable to help in a situation where they're sitting there for weeks not getting the medication that they need.
Mm-hmm.
So it's very
It's an
interesting.
ethical dilemma because we're balancing autonomy, respect
Mhm.
for the patient that we have, respect, dignity that they deserve as human beings, and to make their own decisions. But it's balancing this principle of autonomy with our duty as physicians to do no harm,
Right.
or beneficence, to do good for the people that we're caring for. And that often it collides and causes a lot of conflict in psychiatry.
Yes, it does. Another point that you brought up about like when the patients come in the psychiatric ward, there's an evaluation process. Is the evaluation process in the forensic setting much different from an inpatient psychiatric ward setting? The evaluation that you do, to certify someone insane or with a disorder that may incapacitate them, like, in terms
Mhm.
of committing crimes or whatnot, how does that process differ from an inpatient setting?
Yeah, absolutely. And there is a big difference. Yes and no would be my answer. There are a lot of similarities, but of course, a lot of differences as well. So it's a completely different hat. So
Mhm.
when we're helping our patients, or we're what we call working up a patient, getting the history and getting the physical,
Mhm.
we are forming a therapeutic relationship with our patient, and we have those ethical obligations to do no harm and to do everything that we can to help them. That
Mhm.
is not the case necessarily in a forensic evaluation.
Okay.
So depending on what the evaluation is, there's going to be some overlap. Most of what I do when I do evaluations, when I'm actually sitting down with the evaluee, it's doing a similar history and physical that I would do with if I was treating a patient. So it's a history of what's currently going on, a past psychiatric history, a substance use history, family history, social history. And it's a little, instead of making a treatment plan with a patient, we're offering different expert opinions. And so, for example, to compare that with something like not guilty by reason of insanity, NGRI, the insanity defense, what we would do is parts of that. We would do parts of a regular psychiatric history to obtain that. But the difference is that the flow is also different. So before I would meet with somebody, I would evaluate with my forensic hat on, for the court in an insanity defense. I would do my research beforehand. So it involves going through a lot of records, mental health records, lifetime, whatever we can get, a lifetime of mental health records, their treatment in the carceral setting, all of the legal complaint and the police records. So it's really knowing the crime and knowing the alleged crime and knowing those circumstances. It also involves the evaluation, and it could involve interviews with other people as well. So when I sit down with the person who I'm evaluating to ascertain whether or not I think that they understood what they were doing at the time of the offense, I do a special add-on, which is a competency. Did they, and it's retrospective in an NGRI, meaning I'm sitting here with them now and they may currently understand everything that's going on. But for an insanity defense, we've got to look back in time. And so a lot of that is just the evidence surrounding the circumstances, their behaviors, what they said in the police video and in the interrogation video. And then it's just asking them, what were you going through at the time? What was your perception of things? A different and a similar thing, but it's at a different kind of point in time, is a competency to stand trial. And so instead of retrospective, that's right now when I'm sitting with somebody, and that's when I want to find out what they understand about a trial. And I'd be asking, in addition to the regular psychiatric history and physical, do you know what a judge is? And these are basic questions. What does your defense attorney do? What is a plea deal? Why do you think you're here? Some people have delusions in the courtroom where they think the jury is in cahoots with somebody else. And these delusions can be very elaborate. If they think that they're being persecuted by something, I mean, it can be somebody else. It can be malevolent figures like the devil, things like that. They can think the judge is collaborating with them. And so if that's the case, and I ascertain that in my evaluation, I have to say there's a serious misconception, that they're having about the trial that renders them not able to competently assist their defense attorney here. And so no, they're not competent to go to trial. Or yes, they are. They understand enough that they can work with their attorney. And ultimately, this is all to be just, to do the right thing, to serve the justice system, because we shouldn't be putting people through a trial that don't understand where they are and what's going on. That's not justice.
At the end of the day, if they don't understand what's going on, it might even turn out in the worst case scenario for them if they, I don't know, get on trial or serve as a witness in their own case and they just have these thoughts of what's going on there that may not be true. It can definitely cause them more harm than good in certain situations. I would like to ask you, I guess, more of a clarifying question regarding your role in a case such as the one you were just referring to. A lot of the reason behind why we started this podcast, to let you know, is one of the reasons being that we want to debunk common misconceptions that, young people that are just kind of getting out in the world, they may believe about medicine, health, wellness, that they may have found on social media, through other forms of media, television, movies, things like that, to hear it from the experts themselves. And so for someone that has very little knowledge of psychiatry, especially forensic psychiatry, the role that I see, or my perception of your role as a forensic psychiatrist, is made up of things that I've seen on CSI or Law and Order, SVU, where I see, like, you said it, like, coming in as an expert witness, but that's just like a very probably Hollywood version of the perception of what your role is in a case like that. Could you help us to understand more, like bring more accuracy and more insight into what your role in a criminal civil case is as the expert witness, as a forensic psychiatrist?
I think one of the main things to understand about an expert witness, like a forensic psychiatrist, is that at the end of the day, they're not making decisions about the outcome of cases. They're here to help the judge or the jury make a decision. So what they say may have a lot of bearing, it may have no bearing.
Right.
They may be right, but it's not taken into account or it's not relevant for the case. So a lot of it is we don't have as much power, I think, as people think we might in an actual case or in an actual courtroom. So we're a part of a case. We're not the whole case. Now it depends on the case, right? Because some cases it may hinge much more on what the expert opinion is. But often we have dueling experts. And so it can be difficult because in psychiatry there's a lot of gray. And so I think when a forensic psychiatrist is offering an opinion, we do this based on evidence, the literature, research, what we know about psychiatry. So we're not just winging it. There's a systematic way to approach this. But oftentimes it's not just one person. It can be another person where your opinions are really challenged. So it's not necessarily one forensic psychiatrist and they're deciding everything that happens with the trial. There's more often than not a lot of pushback.
Okay.
And I think another misconception is that we're hired guns, meaning that when we are consulted by an attorney for a case, that I'm trying to help the attorney win the case. And I'm not trying to help her win the case. that's not, I think it can be an insidious slip into that. And I think you need to know your biases and to make sure you're not doing that. But I'm here to advocate for science. I'm here to advocate for psychiatry. So I am not on their side. I am an expert witness. And often when I'm consulted for things outright, I can say, I can't really help you with this case. I see a problem here, there, and there. Or when I'm actually retained on a case and I'm doing my research, I'm going through the records, or after I evaluate the evaluee who might be accused of a crime, I might come away with an opinion that is not favorable at all. And I have to tell it like it is. And I have to say, hey, actually, this is not the case at all. And it could be, I think they were sane at the time of the crime. That's what it shows. And so we're not hired guns. We're here to advocate for our opinion, not a side necessarily. And I think also there's some limitations in our ability to do some things as well. We're not predicting the future is not something anybody can do. Much less, the psychiatrists. I mean, we try to do that, but we try to prevent violence. We can't necessarily predict things. So we do the best that we can in these terms, but we're not soothsayers. We can't do that. So I think the most, sort of to conclude here, is that we're a part of the trial. We're not the whole trial. We're not hired guns. And we may not be also as powerful as you think that we might be.
It's honestly an ethical dilemma in itself. It seems to separate like the truth and evidence of a case from that person, the defendant, like as a patient too. It seems like it's so hard to separate the two, especially from you as a psychiatrist. Like, how hard is it for you to not see them as like your patient?
Yes, and then we refer to them, we make it very clear they're not a patient. And in fact, in the beginning of every single evaluation that I do with somebody, that's the first thing that I say. I say that I'm a forensic psychiatrist. I'm here to do this evaluation because your attorney wanted it for this reason. And I am not your doctor. This is not a treatment relationship. This isn't confidential. So very, very different from clinical medicine. And so I have to make sure that they understand that, because they can slip into this. They may actually tell me things that they think might be confidential, or they may think I'm trying to help them. And I'm trying to help justice while preserving their dignity. I'm not necessarily trying to help them. And so, yeah, I'm still a compassionate person I'm a psychiatrist. Above all, I treat patients. And that's what I love about psychiatry. And so I can't turn that off when I'm with somebody, especially somebody who's, I mean, we're not that they've been through a lot. They're in the criminal justice system. And I have to partition that out because the results of what I do it may go quite terribly for this person, and that's something I do have to sit with. So it can be, I think, emotionally challenging often.
Dr. Robinson, you mentioned the ethical dilemma of being an expert witness in a case. I was wondering your thoughts about the ethical nature of, so there's a famous case from UCLA, I believe in the 70s, and now it's a doctrine in some states, not every state, where a psychiatrist or I think any medical professional with a patient that they reasonably believe might harm someone, they have a duty to report that to the local authorities. That brings up this ethical dilemma of what's best for the patient, what's best for these people that they supposedly may be harmful to, and where's that line of when do you reasonably believe. It's like a pretty classic law school kind of answer, exam essay. So I was wondering your thoughts on that ethical issue outside of the courtroom.
Yes, you're referring to Tarasov, I'm assuming.
Yeah, it's Tarasov.
Yes, that's a classic. All psychiatrists, we learn about that, but especially in forensic psychiatry, we learn case law in forensic psychiatry. So this is one of the landmark cases. And but what happened with this case at the end of the day is that it was adjudicated that we have to be, there are some limits to confidentiality. So typically we think of HIPAA, everything has to stay between, is very tight. Our privacy is very tight. However, there are times when we have to break HIPAA and break confidentiality. And that's when we think that somebody is a danger to themselves, potentially, or a danger to others. Now, it varies widely state to state on what's required and what to do and who to report to. But it is a particular problem in psychiatry. And after Tarasov, there was a lot of pushback by psychiatrists because if a patient is coming into an evaluation and maybe they're thinking of suicide, do they not want to tell the psychiatrist how they're actually feeling because they're afraid that the psychiatrist might call the police on them and come to their office and pick up their patient? I mean, that's a huge breach of trust, and the therapeutic relationship can be absolutely destroyed by that. Now, not all the time, right? But we have to do what we think is right. And so when we think that somebody could hurt themselves, could suicide, we have a duty to try to stop that by the way that we know how to. And sometimes that's doing some sort of intervention like, okay, I'm going to see you tomorrow. I'm going to call tomorrow. I'm going to do this. But sometimes it's saying, I think you need to go to the hospital. And the same thing applies to harming somebody else. And so the psychiatric community was concerned that this is just going to destroy psychiatry, that people aren't going to want to tell them their deepest and innermost feelings anymore because they're afraid of what they're going to do. Now, just as a clinical psychiatrist, what I will say is that this is still a problem that comes up. When I get really worried about what patients tell me, and I want them to be honest. If they're suicidal, I want them to be okay telling me they're suicidal. But often I'm given this information and I'm wrestling with it. I mean, this is things sometimes, you want to leave work at work, but sometimes it's hard to. And you think and you worry, did I do the right thing? And so ultimately we can't know whether we did the right thing. All that we can do is try to think and reason through and put some thought on it, consult other people. You're never an island. You can always ask another professional how they feel and what they think about it. And then you do what you think is right. And sometimes that is calling an ambulance and having them admitted to a psychiatric unit. It's a difficult call, but it's an ethical dilemma that most psychiatrists deal with frequently.
And obviously confidentiality is a major part of someone's legal rights in the medical sphere in America, thanks to HIPAA. It's also a big part of your legal rights when it comes to your attorney. There's the two kind of like landmark, rights you have as a citizen. But it comes up all throughout law school, all throughout different classes where people's medical history is used against them. It comes up in domestic cases. It comes up even in civil suits, even in criminal suits. Even when it's not relevant, it could be used at sentencing. And on one hand, it's the truth. This history that someone has could necessarily be relevant to this thing that's being decided in court, but also it's someone's confidentiality and it's someone's personal struggles that's being used against them. So I'm wondering your thoughts on that sort of broader ethical debate of making the most maybe accurate decision for a court and trying to protect people's rights.
There is a big push, and I try to teach this to my fellows and residents, in that just because this is an objective evaluation and there's no doctor-patient relationship does not mean that this person isn't afforded dignity and respect for persons, and compassion is important to me, even for somebody I don't have a treatment relationship with. And what that means is sometimes the things that they tell me, they're really not relevant to the case at all. And they may be something that's very sensitive, something that happened in their youth, something embarrassing, something personal. I don't have to put everything in my report. I don't, because it's embarrassing. It can be humiliating. And it ultimately is, I just don't think that it's right. And so I think you need to be careful that you want to be thorough and you want to consider what's important, because lots of things are important. Lots of facts are important, especially when you're dealing with a complex case with a lot of records and a lot of history. But you have to filter through things. You can't put everything in there and expect people to be able to discern why it's important. You need to be somewhat succinct, and you need to be a good communicator. And so you can't use medical jargon when you're testifying or you're writing a report. You need to write this in a way that ensures that a judge or a jury, anyone from a jury, can really understand what's going on. And so for me, and how I live this principle of respect for persons, is that I don't put things in my report that I don't think are relevant and that are embarrassing or humiliating. That's extremely important to me.
And you also mentioned, being ethical generally when you're being a witness for court, not being a hired gun. That's the classic criticism you hear of any expert witness, especially medical, experts in any courtroom. It's one reason why legal scholars and judges tend to historically not love expert witnesses. They don't love science or even math in courtrooms because they think that it can be used to confuse people. And they think that, the one side is just going to get their guy and they're going to say whatever they want. So have you ever encountered in reality someone, across the case from you, maybe on the other side, who you thought maybe wasn't living up to the same ethical standards and maybe was being more of a hired gun?
You bring up an interesting point about experts in the courtroom and how they're mistrusted sometimes as hired guns, because experts can be in any field. They can be in medicine, it can be an engineer, it could be somebody who's in sales, it could be anybody, it could be an expert witness. I would say that there's a particular difficulty with understanding psychiatry in the courtroom and psychiatric testimony because of its history. I mean, there's a lot of jargon, and I think a lot of what people think psychiatry is the psychoanalysis and what's the Freudian principles, which I think are all interesting and well and good, but there's a lot more to psychiatry over the past 100 years is what's happened. So I think there's a particular maybe coloring of psychiatrists in the courtroom. And so I think in general, everyone in their career has a case where there's an opposing expert, and your opinions on the opposing expert, at the end of the day, you give them respect. It's another physician. They have their point of view. I will never pretend to understand anybody's motives at all. More often than not, when I'm looking at an opposing expert's report, I'm thinking, oh, that's a really good point. Like, I didn't I didn't think about that, or that's a piece of information that I didn't consider. And in psychiatry, this can happen because there are such grays, like you can view a course, or you can view a case from really either end, and there's truth is somewhere in the middle more often than not. And so I'm going to be careful about not doing particular things, but I think I've never had a case where I didn't have respect for the opposing person. And I think the more important thing is monitoring yourself, because that's all you can do. And say, what sorts of biases am I coming? Am I coming with a confirmation bias? Am I coming in because this information was presented to me first, and so I'm hanging on to that? Or have I had a theory all along, and then all of a sudden, months, years into the case, I find this piece of evidence that destroys everything? And I mean, these are the things that you can control. So I think less than worrying about the other person is you got to worry about yourself and make sure that you're not slipping into that, because it's very easy to.
I have one more kind of, oh, sorry, Matt.
Dr. Robinson, I was going to ask you, for myself or any of our listeners that may not know logistics of the process, like you were mentioning confirmation bias, how privy are you to the testimony given by an opposing expert witness? I mean, like, are you like, sort of like seeing the report, like what they're saying, what their diagnosis is, so to speak, if they do have one?
Mm-hmm. Yes. Whenever an expert writes a report, absolutely. Absolutely. You see the report. That's in my practice. That's in everybody's practice, because you're still involved in the case. The case is still going. And if there's an opposing report, that probably means, or it's likely that the next step is you're going to be deposed. After that, you may go to trial. And so you're going to have to know a lot of these things. But also, I just want to know weak points, right? Because when sometimes they do a rebuttal report and they're directly critiquing your report.
Okay. Wow.
Yeah, that's real fun.
Yes. You feel like you have to respond back to, I'm sure.
That's really fun. But when they testify in the courtroom, I don't stay, because really I'm not there because I'm not there to see them win. It's not, I'm there to give my opinion and to separate myself. And so I don't sit in the courtroom watching the whole trial. Now, that's just me personally. I mean, there's certainly nothing wrong with it, but I think just from, the optics of saying that, I'm not like invested sort of in the outcome necessarily of the trial. But I will learn about the testimony, at some point in time, more often than not. But I don't sit there and wait for it. But I definitely see the report.
I've one based on that. You mentioned earlier being cross-examined when you're on the stand, and for listeners who don't know what that means, when you're a witness for one side, you're examined, they ask you questions. The other side can then choose to cross-examine you, where they come up and they can grill you, they can ask leading questions, they can be kind of hard on you because they can kind of be making a point. Often with any witness, what they're trying to do is get them to trip up and maybe have inconsistencies or maybe look not credible, try and like weaken their testimony. So I was wondering if, while being cross-examined, you're kind of on the spot, have you ever found it difficult to kind of hold your ground and even like remember what you said in the report? Have you ever felt like you were kind of tripped up by a lawyer who was trying to get you to maybe forget what you said earlier or just say something wrong?
Yes, absolutely. We're human beings, and I'm not a robot. I can't remember everything. I can't remember everything. I really, before you go and you testify, the facts cold. You do your homework. You read your report. You make sure you know your facts and your report forwards and backwards. Because that's what they're going to ask you about. You are correct. The opposing attorney, when you're cross-examined, their job is to discredit you. And so they're going to question your credentials. They're going to ask you about your biases, things like how much do you get paid? How many cases have you done for the prosecution or for the defense? And it can be a pretty unpleasant feeling, because that is their whole purpose of cross-examining you is wanting to discredit you and then therefore your opinion. And it can be several hours of that. And so this is not necessarily a profession for the faint of heart, but it's not that all the time, you know. And I think most people are decent and they're not there to give you a terrible time. But it just depends, you know. It depends on the case. It depends on the attorney. There's a lot of personalities involved here, but it can be very difficult to be cross-examined for 3 to 4 hours, and they want you to be flustered, and it's hard not to get flustered sometimes because you're trying to remember things and the way the questions are coming across, you know, you can contradict yourself. It happens, you know. You're a human. You do it to the best of your ability, and ultimately I go up there and I just really steel myself up for my opinion. It's my opinion, and I'm trying to do the right thing. I'm here for justice. I don't have anything to hide. You know, I crossed my T's, I dotted my I's. I've had more difficult ones. One cross-examiner called me Miss. That wasn't great. I had just gotten done testifying as the expert witness in the case for several hours. I mean, for 3 hours, I just testified, and then he cross-examined me, and he called me Miss. Any advice for young women when that happens? You correct them. You correct them right away. That, you know, you're a doctor. That's why you're here. But who knows? Was that a strategy to try to trip me up, to fluster me? I don't know. But it can be very difficult up there. It can be, you're getting grilled for sure.
Dr. Robinson, another misconception that I would like to ask you about, it's twofold, in that a lot of people have the perception that in criminal cases, pleading insanity can be an easy way out. And earlier we were talking about, and you likened a psychiatric ward to a prison. So my question would be that how easy is it to get away with pleading insanity when you may not have been insane or incapacitated in the moment or at the time of the crime? And then the second being, is there actually an upside? Is there an incentive for someone to plead insanity when they're probably going to end up in a place that may even resemble or be very similar to treatment or quality of life they would experience in a prison?
Mm-hmm. In general, insanity pleas are it's very difficult to get what we call NGRI. They're successful in only usually a small fraction of cases. I mean, in terms of statistics, I don't have them right here, but it's an uphill battle, even if there's a legitimate case, to have that be the outcome for someone. And so it's not something that people get off with, you know, or they're excused from the crime. I think in general, people probably who are, the laws and the standards differ state to state in terms of what they consider insanity or what they understand is radically different. And so in the face of justice here, we would really want people who don't understand what they've done or couldn't control themselves at the time because of their mental illness to get treatment, not be incarcerated.
Right.
People can be psychotic and can understand what they did. So just because they have a mental illness and they have something like schizophrenia and were psychotic, it doesn't mean that they didn't understand what they were doing at the time of the offense. I think that's very important too, to know that's why you need an expert to evaluate the person and ask those specific questions. Yes, you might have been psychotic, but that doesn't mean that you don't understand things and you can't operate and use logic. I think that's another misconception, that people with schizophrenia have no idea what's going on, and they're just kind of out there. No. That's not the case. When people are actually adjudicated NGRI, they go into a forensic treatment facility. And so this is a facility where they are treated. I mean, more often than not, sometimes against their will if they don't want to be treated. But they need if they're currently psychotic, they may need treatment. But if they are found NGRI, the other thing is that they are held in an indeterminate sentence. So when you are found guilty, you are given a sentence. So I have 30 years.
Yeah.
Yes, if you're found NGRI, it can be longer than 30 years.
Wow.
Yeah, so it's not necessarily better to even be found not guilty by reason of insanity necessarily. So a small fraction of the cases are actually considered and ruled not guilty by of insanity. And even if you are, it's not necessarily better.
That's such a good point that most people don't think about. You're treating the patient over a long term. There is probably no end to that for certain, psychiatric conditions.
But it's also they may have committed a violent crime. And so when are they released? I think that's the question, and that's why it's difficult to know that, right? When do you think somebody that's been found not guilty by reason of insanity is safe to be discharged into the community? That's a tough call for a treatment team to have to make. And so that's why it can extend beyond the sentencing if they were found guilty.
Well, if someone were to be found NGRI, how involved would the expert witness be in setting up a treatment plan? Would they be totally removed from that process, and that person has like their own treatment team, or is there any sort of role that you play in the next steps for that person, so to speak?
Usually it's concluded at that point that you don't have a role in treating that. That's shifted to the facilities, whether that's a facility within a prison, whether it's a different forensic psychiatric unit, which is a locked unit for people involved in the justice system. There are treatment teams there. There are doctors and physicians there, and it is their job to take care of their patients. The people there, they become their patients. So at that point in time, I don't have any direct role in treating at all. I may, if it's required or if it's appropriate, be asked to recommend some treatment options. Sometimes that's appropriate, but more often than not, my involvement ends there.
I have a question that's maybe a little bit esoteric, but I feel like you're the best person for this. It's something that I've thought about for a while since my first year of law school taking criminal law. So the insanity defense is an affirmative defense saying that, I did this, I had the mental state, but I couldn't sort of comprehend my mental state. So something blocking I wasn't conscious in the way that a person would be, even though I did it. It's similar to the intoxication defense. For the same reason, I was intoxicated, I couldn't comprehend what I was doing. But a lot of states have been moving away from the intoxication defense because it's just too difficult they think, for juries to even comprehend, what does that even mean? It kind of goes to this bigger question. It's almost like philosophical of, what is thought? What is consciousness? When are we aware of what we're doing, and what does that even mean? So I was wondering your thoughts on that generally, and then, how you think that should play into the courtroom and then into your work as a witness.
Addiction and substance use and intoxication, it is a very, very interesting and deep question when it comes to free will, right? If somebody has an addiction, what is under their control and what isn't? Surely something is under their control. But I think just probably what I know from being a physician, what I know just from being a human being, is that there's a certain definite lack of control at some point in time from addiction. And as we're coming to a more medical model of things, we're starting to understand addiction more in that what's actually happening, but we don't know person to person what's under their control and what isn't. For NGRI, at least here in Illinois, you cannot say intoxication does not count unless it was involuntarily done. So if somebody spiked your drink, gave you a medicine that you thought was another medicine, and then you did something illegal while you were intoxicated with that, you could be argued that wasn't your fault, but that's an exception. So it's a very interesting question, and I think that in general, there's still a big stigma against substance use and people with addiction in general, right, by society. And so understanding addiction in a forensic context is difficult. And what a forensic psychiatrist might do is in the realm of like a sentence mitigation. This is just an example. If somebody did have a severe heroin addiction, and they stole something, to fuel their habit, they stole something, or they hurt somebody. I mean, there needs to be some justice. Things are under their control, but the question is what is and what isn't. And so if there were mitigating factors like, yes, this is it is a crippling addiction, that there's mental health issues too, that they're living in poverty, etc., that might be offered as mitigation to a sentence, for example. But in general, the law still looks at it pretty black and white. If you did something but you didn't know what you were doing because you were intoxicated, that doesn't count. And you bring up an excellent point of what is willpower? Where does that begin and where does that end in addiction? Now, we can't force treatment. We can't force addiction treatment. So what I just explained to you earlier, in that if I think somebody wearing my doctor hat, on an inpatient unit, if I think a patient needs medication, but they are refusing it and they are very sick, they are hallucinating, they're psychotic, they're in distress, I will file a petition and take them to court to do that, to give them, and with my testimony, if the case has merit and the judge feels that way in mental health court, they grant me the petition and we can start treatment over their objection. The same cannot be said of substance use. So we can't force people into we can't force people because of addiction into treatment or psychiatric wards. And that's interesting. And I really don't know. And I think looking at things with compassion, I think it's something that we in society have to think about a little bit, because we can't trample autonomy necessarily. But at a certain point in time, there's a concept of rotting with your rights on. And we use that as a term in psychiatry for this overbalanced emphasis sometimes on autonomy and rights, because we're a culture that's very rights driven and autonomy here in America. It's very focused on the individual. So we think we give people a lot of rights, but this extends to psychiatric treatment as well. And so sometimes we come face to face with the law saying that, no, this person's rights kind of supersede this, or, you don't have enough to treat this person, or you have to let this person has to be discharged. So we have to grapple with that. And so we call that, you can see homeless people as well, and you see mental illness on the street every day. And that's an example of rotting with your rights on, right? Like, they have the right to be psychotic. They have the right to be on the pavement in the middle of summer. They have the right to not have clothes on. They have the right to be eating out of a garbage can. That to me is an abhorrent view. And I think it is just this thing that we grapple with in psychiatry, of where we're coming face to face with the law here, and what is on the books, and what versus what we know is right. And so I think extending this to addiction, there are some similarities, right? There are some, but there's a lot of differences too. And so, Will, you bringing up an excellent, not so esoteric, but a very relevant question that I think we're still grappling with and trying to understand in the field.
Dr. Robinson, thank you so much. This was super interesting. I feel like we could sit here and talk about this for hours. I want to be mindful of your time and listeners as well. To close us out, because you have such an interesting career path, the way you've gotten here, and such an interesting niche in medicine, I would love to hear just sort of your general advice to anyone looking to pursue a career in medicine.
Yes, we talked about this a little bit in the beginning. I am a firm believer of following your heart and following what interests you. There is a lot of pressure, I think, to have everything all figured out these days. You start college, what's your major? You're a freshman, what's your major? I don't know, I haven't even done college yet. Do you want to go to med school? Oh, I'm 18. So do what you love. Take the classes that you like. There's always some forethought, right? And planning and executing what you want for your future and your dreams. But if you keep doing what's interesting and what you love, you will get to where you need to go. And that's all I never thought in a million years I would be here. If I was 18 or I was 12, a little girl, but I just did what I loved. And that's sustainable. Because all of this is heavy. And if you're in medicine in general is a very taxing field. And you need to have balance in your life and you need to take care of yourself. And if you're doing something that you're finding that you're lacking passion for, then I think you need to check in with yourself to see how you're doing. So this is very flowery probably, but I really think follow your heart and do what you love.
So
That's
true.
awesome.
It's such good advice. The thing you choose at 18 doesn't have to be the thing you do the rest of your life. So thank you so much, Dr. Robinson. This has been amazing. We were so excited to have you on and talk about the complicated, complex, and very interesting field that is forensic psychology. So thank you so much for taking the time to meet with us this evening.
Absolutely. Take care.